NACDL is the association of the nation's criminal defense bar.
So today our panelists will be discussing sort of the discriminatory use of peremptory strikes in jury selection, and then also avenues for reform, including highlighting recent legislation that was considered in Colorado to tackle this issue, as well as successful reforms implemented in other states. My name is Monica Reed. I have the pleasure of serving as Director of Advocacy here at the National Association of Criminal Defense Lawyers. We are excited for today's webinar. We've assembled the nation's leading jury experts, including NACDL's Public Defense Counsel, Monica Milton, who will be moderating today's panel. Before I turn it over to Monica to further introduce the panelists and to get us started, I just want to take a minute to go over a few housekeeping items and announcements. So one, we encourage you to introduce yourself in the chat, your name, your organization, and where you're located. For questions that you would like our panelists to answer, please use the Q&A feature, which is going to be at the bottom of your screen, and we'll make sure those are included and asked throughout today's conversation. We do apologize in advance if we don't or are not able to get to your question, but we will be sharing the panelists' contact information toward the end of today's session. So feel free to contact them if your question isn't addressed during the webinar. And then lastly, I want to take a minute to just highlight NACDL's Code of Conduct for Affiliated Persons. So this applies to anyone who attends NACDL's sponsored events, and this includes our virtual events as well. We shared it earlier in the follow-up email once you've registered, and we'll share it again in the chat. But to summarize, we just seek to foster an environment that is free from harassment, discrimination, intimidation, and insult. And that includes any offensive remarks, comments, or questions. And so if it is determined that you have violated the code of conduct while participating in today's session, we will remove you from the session. So just ask you to be respectful for the content and your fellow attendees, and of course to our panelists as well. And then lastly, let's really, in considering language, especially as it refers to those who are incarcerated or formerly incarcerated individuals, let's just seek to refrain from using any dehumanizing language, such as felon, offender, inmate, ex-con, or convict, and let's just use language that restores dignity and humanity to those who've been impacted by our criminal legal system. So with that, I'm going to turn over to Monica Milton. Again, she is NACDL's Public Defense Counsel. She's going to further introduce our topic and our panelists. And thank you so much. So take it away, Monica.
Thanks, Monica. And just to confuse you all with our same names, as Monica said, I'm the Public Defense Counsel here at NACDL. And why don't I just let the panelists introduce themselves? I'll just go in alphabetical order. So Tristan.
Thanks, Monica. Good afternoon, everyone. My name is Tristan Gorman. I'm the Policy Director for the Colorado Criminal Defense Bar. I've been a practicing criminal defense lawyer in Colorado for the past 12 years, and now I do our lobbying at the state capitol.
Yes, good afternoon. My name is Paula Hannaford-Agor, and I am the Director of the Center for Jury Studies at the National Center for State Courts.
I'm going to say good morning since I'm coming from the West Coast. Good morning, everyone. My name is Brendan Woods. I'm the Public Defender of Alameda County, the Bay Area, Oakland, Berkeley, and so forth. I've been the Public Defender for almost 10 years. I've been with the office for a very, very long time. I'm not going to say, and I'm very, very happy to be here to discuss this topic.
Great. Thank you all for being here. If you've attended any of NACDL's other jury events, some of these faces will be familiar as they have been some people that we've leaned on a lot to discuss their experience, especially Paula. So given your background, why don't you give us sort of the overview for those that are not familiar with Batson and peremptory strikes and just being really steeped in jury issues. So Paula, can you just kind of give the quick overview of what that is for those audience members that are not as familiar?
Sure. So as many of you know, there are two types of during jury selection, otherwise known as voir dire or voir dire, or there's a number of different pronunciations of it. But basically in the process of selecting juries, there's two ways to remove jurors who are thought to be biased, who cannot be impartial. One is a challenge for cause, and the other one is by peremptory challenge. In most states, other than Connecticut, peremptory challenges are set either by statute or by court rule. And each side gets a defined number of peremptory challenges. Typically, they can range from as few as 3 per side in felony cases to New Jersey actually is notorious for having the most of 20 per side in felony cases. So they vary a great deal. Probably the modal one is 6 per side. Peremptory challenges historically have been basically each side can use that without giving an explanation of why they are using a peremptory strike to remove jurors that they think will be unfavorable to them. The major controversy about this is that historically they have been used often in discriminatory ways, particularly to remove people of color from participating in the jury trial. In 1986, the U.S. Supreme Court heard Batson v. Kentucky that was a challenge to the use of peremptory challenges in a discriminatory way. The Supreme Court said that basically allowing parties to use a peremptory challenge to remove a person of color was violated the Equal Protection Clause of the 14th Amendment. And therefore was unconstitutional. And they set up basically a 3-part test three-step process for determining whether or not a peremptory challenge was being used in a discriminatory way. The first step was that somebody needed to, the challenger needed to basically provide a prima facie evidence that this was a peremptory challenge was being used discriminatorily and unconstitutionally. Once that prima facie case was established, then the burden would switch to the person opposing or who had originally proposed the peremptory challenge to give a race-neutral justification for why they had struck that person. And at that point, the trial judge would make a determination of whether or not they accepted at face value the justification that had been made, or that it was pretextual, and in fact, that the challenge had been made based on race, or later on gender. It was Batson was expanded to cover gender as well as civil trials. And so that is the 3-part test. One of the major problems with it is that Batson did not seem to actually solve the problem of the discriminatory use of peremptory challenge. It was just too easy for attorneys to come up with race-neutral justifications that courts were willing to accept. So as a result, very, very few Batson challenges are ultimately successful. And there is a great deal of concern today that people of color are continuing to be removed unconstitutionally, illegally from being able to participate in the jury system.
Thanks, Paula. So I just want to open it up to Brendan and Tristan to ask them their experience with how the peremptory strikes, and I see Brendan smiling already, how peremptory strikes have been abused in your experience. What have you seen?
So I always look at it this way, and we've seen the videos, a lot of us have, with regards to how prosecutors have been trained to give quote unquote race neutral explanations for removing people of color from juries. And we all see Batson, and it really was decided with good intentions. It was a case that was much better than Swain versus Alabama, where the defense had to prove systemic exclusion, which was outrageous that we had to prove prosecutors are racist. So Batson was a real step forward. But as we've seen, anyone who's practiced in our arena has seen over and over again, prosecutors use excuses, which can range from hairstyle, dress, living in a certain neighborhood, knowing people who have been arrested, being close to someone who's been arrested, or looking like someone who's been arrested. All these reasons have been used by prosecutors to remove Black people from juries, particularly. So even though they are quote unquote race neutral reasons, they've ended up making our juries, I want to say less diverse, but probably as diverse as they were originally when it was juries of all white men. And that's where we've gotten from Batson. And we are now in a place where we're moving forward with laws to really look at Batson in a different way, and maybe even to upend Batson. And I always see it as Black people have been removed from jury service, or what I call the Black experience in America, right? Every Black person has been, almost everyone has either known someone has been arrested, or believes police engage in racial profiling, or believe that police maybe aren't trustworthy. And so all those reasons historically have been deemed valid by the courts. And so we see how Batson has been abused to keep people of color off of juries. And I'm glad that we're having this conversation and talking about laws that can change that.
Yeah, I agree with everything Brendan just said. I would just add that the current standard under Batson is obviously problematic for several reasons. But this purposeful discrimination standard, what I've seen a lot of is a Batson challenge is made if it was the prosecution who was trying to excuse a juror of color. The trial judge then asks, what are your race neutral reasons for doing so? And oftentimes it is a fill in the blank of trying to make something up after the fact that could possibly justify the excusal of, or the excusing of that prospective juror that has nothing to do with reality. And the problem is that because of the purposeful discrimination standard, a lot of trial judges even see it as, well, if I deny this challenge, this peremptory challenge that requires no reason at all, by making a finding of purposeful discrimination under Batson, I'm calling this prosecutor a racist in public, on the record, and probably a district attorney who's appearing in my courtroom regularly, both in dockets and trying cases. And we, in fact, just had a case come out of the Colorado Court of Appeals where the prosecutor got in a back and forth with the trial judge and said, you're calling me a racist and I'm not a racist, and got the trial court judge to go back on his own observations of what had happened during jury selection and go ahead and deny the Batson challenge and grant the peremptory challenge that the prosecution had asked for and excuse the juror. That case just resulted in a reversal of conviction on an aggravated robbery, menacing, and theft case from the Colorado Court of Appeals. I can tell you that that does not often happen, but it hinged entirely on this back and forth between the judge and the prosecutor, where the prosecutor said something, it wasn't good enough, the judge sort of coached it along and extracted the record that he wanted to be able to deny the Batson challenge. And then when the prosecutor actually said on the record, you're calling the people a racist and we're not racist, that was when it went the other way. So that's another big problem we see with the Batson standard.
That's really interesting. And I can see that tension playing out. But I would like to kind of delve into some of the science behind why we want diverse juries. Why does that matter? And maybe Paula, you can chime in about some of the studies that have been done that talk about some of the outcomes that we have when we have diverse juries, and some of the outcomes when we don't, and the public perceptions of those outcomes.
Sure. So why does diversity matter? And there's a pretty deep literature, empirical literature studies on this particular question. I think it really it goes down to really two issues. One is that diverse juries just deliberate better. That's one of them. What we've seen from the studies is that sort of the greater the diversity of the jury, and I'm talking not just race, but just the diversity of attitudes and viewpoints, the greater that is, the longer juries deliberate, the more thoroughly they deliberate about the evidence. They have better collective memory about the evidence that's actually presented during trial. They're more accurate in terms of their factual understanding of what has actually been presented. And the jurors themselves report greater satisfaction and more confidence at the end of deliberations with their verdicts. So that's just sort of generally. Race actually has particularly important part of this. Sam Summers is probably best known for some of his work on the impact of racial diversity in jury deliberations, with a number of studies that he did where he actually looks at mock juries with deliberations with all white juries versus juries that had at least 2 or more Black people on them. And what he found was that, kind of surprisingly, that whites actually change their behavior when they are in the presence of Black jurors. They are much more careful and much more systematic in the way that they approach the evidence. They made fewer factual mistakes. They actually raised more issues and discussed the evidence more thoroughly during deliberations than they did when they were in the context of all white juries. This has some real important implications for outcomes. Certainly what we've seen of looking at archival studies is that compared to all white juries, diverse juries tend to have higher acquittal rates. So they're actually coming together and actually finding in favor of not guilty rather than guilt. So that's part of it in terms of just the impact on deliberations. I think there's also an equally important impact on the legitimacy of the verdicts. Leslie Ellis and Sherry Diamond did a very nice study on this where they looked at how people perceive the legitimacy of verdicts when it's described as an all-white jury versus a diverse jury. And the thing that they found was that when the jury, looking at sort of a fact situation that are exactly the same fact situation, but when people hear about this and it's an all-white jury, they perceive that the verdict is less fair and less accurate as compared to with a white jury or with a diverse jury. It actually, the outcome of the case doesn't matter whether it's a conviction or an acquittal. The juries actually feel that the diverse jury is more fair and more accurate. So I think that's actually really important in terms of just the democratic institution of the jury and the public trust and confidence in the verdicts that are coming through. That idea that we actually have diverse juries so that the public has confidence that justice is being done.
Thanks, Paula. And so I just want to pull on that acquittal thread a little bit. What do you all think, Tristan and Brendan, about, if prosecutors are saying, you're just saying I'm racist, when I'm just trying to win, right? Isn't everybody just trying to win and, increase the likelihood of getting that guilty verdict and moving on from the case? What is your response to, it's not racism, it's winning?
I don't mind calling them racist. I'm sorry. But I'm also in Oakland, California. We can probably get away with that more. So it often, it's been a while since I've done trial, but we'll have that colloquy between myself and DA and like, well, you're calling me racist. I'm like, well, stop kicking Black people off. and so we go back and forth. When it comes to Batson, I believe in the process of objecting early, objecting frequently, and putting them on notice that we're not going to allow them to remove Black people from juries, and especially if my client's Black. I think it's really, really important to set the stage to say, I value you, and I'm going to value everyone that looks like you on this jury. So when it comes to the prosecutor thinking you're calling them racist, I Batson frequently because it does get in their mind, and they think, well, maybe I might be, or maybe he's calling me that, so I'm going to be more conscious with regards to how I treat the jurors that are coming up. So I honestly have no problem with it, and I'm really, really okay with it. So I'm curious to hear what Tristan's answer is.
Thanks, Brendan, for that. I would say two things in response to a prosecutor saying, I'm just trying to win, both sides are just trying to win. First off, prosecutors have an ethical duty to seek justice, not convictions. So it should never be just about winning to them. And I find it concerning if there are prosecutors out there saying that. Within the context of a case where that they're taken to trial, that they think winning the trial and getting a conviction is justice, what I would say is that particularly in this arena, in voir dire, they need to broaden their gaze a little bit, because it's not just about the rights of the accused. It's not just about the outcome of that individual criminal trial. It's about the right of anyone, regardless of the color of their skin, to participate in our democracy. And besides voting, the jury system is probably where most folks are going to have the opportunity for that participation. And I think systematically excluding people of color from jury service, whether an individual prosecutor recognizes that as racial discrimination or not, is going to have a profound impact on people of color who are excluded, and ultimately undermine their confidence in the system, because why should they trust a system that won't even allow them to participate?
So let's turn to what's going on in Colorado. There was some legislation that sought to address, the issues that we're talking about. So why don't you, Tristan, tell us what happened, what it was supposed to address?
Well, I will try not to turn this into too long a story, but we have had quite a ride on the Colorado legislation this year. So first off, you need to know that it is Colorado Rule of Criminal Procedure 24 that would govern here, and there was a proposed rule change last spring to that rule of criminal procedure in Colorado. The Criminal Rules Committee met. They issued both a majority report and a minority report, wherein a majority of the Rules Committee voted for the Colorado Supreme Court to adopt a proposed change to the rule that was virtually identical to the legislation that we eventually saw introduced. Last March, the Colorado Supreme Court rejected that proposed rule change, and the only rationale they gave for that rejection was lack of consensus. I do think it's worth noting that there was one judge on the Rules Committee who voted against the rule change, and all the rest of the no votes were from prosecutors. So despite the majority vote on the Rules Committee being to adopt the rule change, there was no rule change. Literally nothing has happened with the Colorado Supreme Court or that Rules Committee in the years since then. So in the meantime, our sponsors introduced Senate Bill 128 on February 9th. And that was a bill to address implicit bias in jury selection. So in other words, not to simply rely on the purposeful discrimination standard that is in Batson. That legislation gave several presumptively invalid reasons for a peremptory challenge, so that the burden would have gone back over to the party who was trying to excuse the juror to show why it was not the result of implicit racial bias. Those reasons included things that were not controversial to the opposition of the bill, like residing in certain neighborhoods, having a child outside of marriage, receiving state benefits, or speaking English as a second language. The presumptively invalid reasons that were in the bill that were the subject of a lot of controversy and that were uniformly opposed by prosecutors were having previous contact with law enforcement officers, expressing distrust of law enforcement officers or a belief that law enforcement officers engage in racial profiling, or having a close relationship with an individual who has been stopped, arrested, or convicted of a crime. So that was one of the major subjects. This bill went to one legislative committee hearing. It was before Senate Judiciary Committee. The only people opposing the bill officially were prosecutors. All 22 elected district attorneys and the Colorado District Attorney's Council opposed the bill. And I believe about 6 of them testified in opposition. What was interesting there is that all 6 of those DA witnesses said on the record to the Senate Judiciary Committee that implicit bias is a problem in jury selection in Colorado and that it does need to be addressed. And the only concrete solutions they offered for addressing it were, it shouldn't be a bill, it certainly shouldn't be this bill, it should be a rule change, which of course they had already managed to overcome in the Rules Committee. And they also said that they all train on implicit bias and that we should continue training, which confounded me, since obviously that hasn't solved the problem. I'm not sure exactly why continued training would. But they ultimately overcame the legislation. It did not have a path forward on the floor because of the opposition by prosecutors. So my understanding is after the bill died, the sponsors sent a letter to the chair of the Rules Committee, setting out some expectations about what we are hoping to see as far as action on a rule change, or if that does not ultimately happen, the expectation of future legislation to be introduced on that topic. We also had a lot of press coverage of this particular bill and had a few appellate decisions come down while it was pending that I found particularly interesting. One I already discussed. Another was sort of an exercise in what it takes to overturn a conviction under the current Batson standard. That was a case out of Denver where it was sent back down because the Supreme Court didn't see a race-neutral reason, where the prosecutor was literally in the transcripts referencing the fact that the prospective juror she was trying to dismiss was a Latino male. So it took the prosecutor coming right out and saying, I am trying to dismiss this person of this race, for the Colorado Supreme Court to apply Batson and say, no, we're sending it back down. Beyond that, there's been a lot of confusion apparently on what exactly the Batson standard is, how it is to be applied in trial courts, and we've seen some limited remands on that basis. But as far as the legislation, as I say, the prosecutors generally opposed by saying, you can't have these presumptively invalid reasons. Why don't we have, mirror those reasons on the other side? You're going to be skewing juries toward the defense and against the prosecution. You're going to be coming up with juries that believe police engage in racial profiling and we have to use police officers as witnesses. And you're automatically going to be starting out with a jury who cannot lend any credibility to those officers. And we came back with all of the arguments about, well, this is how challenges for cause work. We're not in any way impacting challenges for cause with this legislation. If someone cannot listen to the evidence and be fair and impartial in a case, then a challenge for cause should be granted on that basis. We already have in jury selection arguments about whether or not you're lending more or less credibility to a particular witness because they are law enforcement or they're not law enforcement. That basically seemed to fall on deaf ears. And the way the prosecutors approached the legislation seemed to be, this is going to be unfair to us and our ability to secure convictions. And that was largely the basis of their opposition, and I think why the bill died.
So any thoughts from Brendan and Paula on prosecutors so heavily opposing such a change? I mean, Brendan, like you described, some of these proposed presumptively invalid reasons for kicking someone off a jury are part of the Black experience. So what are your thoughts on these prosecutors being so adamantly opposed? What's your retort?
I think it goes back to a comment that was made earlier. Prosecutors, I think, care more about winning than they do actually about justice. They care about what they think might give them the best advantage in a trial. I think they feed into prior stereotypes and implicit bias and explicit bias that existed in this country forever. And the way the system works, as we all know, is that if you have jurors that are more likely to convict, that drives up the punishment, it drives up the charging, it drives up everything that's wrong with the system. And so I really think that there is an argument that should be made when it comes to peremptory challenges, that if we want the system to really work, they should be eliminated for the prosecution. They should be removed completely for the prosecution and only be allowed to be exercised by the defense. Because if we think about it, who's got the burden of proof? Who has to prove the case? Who has all the resources behind them to actually prove the case and bring the case? Any prosecutor should be able to get a conviction with any 12 that's put in front of them if they're going to meet their burden of proof. So I think there has to be a fundamental shift with regards to how we view trials, view outcomes, and view justice, and how prosecutors treat their burden. And so in order to do that, we need to have this conversation. And I think every argument made by a prosecutor to object to either GR 37 in Washington, AB 3070 in California, SB 128 in Colorado is ultimately disingenuous. It really, really is. Because if you're going to sit there and say you care about outcomes, if you care about bias, if you care about prejudice, then you should not be objecting to these laws. You should not be objecting to these bills, because this is the way to equalize that and balance it. So that's my views on that.
So just to chime in here in a slightly different view, my thoughts on this that sort of the arguments that that these biases and the importance of being able to remove people who have real life experiences in their communities actually is a real disservice to the juries themselves. Jurors actually pay really close attention to the evidence, and they really want to get it right. And so if the prosecution has the evidence and can prove their case beyond a reasonable doubt, they should not actually fear that people with experiences, real life experiences that we know that people of color in these communities have on a daily basis, that they're not going to get a conviction. It's not like people of color want to have crime in their communities. They want to hold people who are dangerous accountable. So that sort of thing of we want to weight it just a little bit more, I think does a disservice of not actually trusting the jurors to get it right.
So is there an incentive for prosecutors to, what's the incentive for the prosecutors in Colorado who have adamantly opposed this, short of just having a different value system where you care about, the perceptions of legitimacy? What incentive do they have, or why should they care about these issues? If it's a bunch of prosecutors who are saying, I'm not racist, but we don't want these Black people on these juries, they're not going to be fair. What incentive do they have to actually join in with some of these defenders and people in the community to make any shifts? Is it hopeless in Colorado?
Well, I certainly hope that it's not, but I can't say for sure that it isn't. As far as incentives, we've heard a lot over the past couple of years from both law enforcement and prosecutors in Colorado that they need to rebuild trust in the community. They need to have the community trust them. But the reality that I see is that they keep engaging in conduct that is going to undermine community trust with anyone who doesn't look like them, think like them, and have the same beliefs that they do about crime and what they call public safety. One of the points that I've made in this discourse a lot is that public safety has to include everyone. I think that prosecutors have sort of leaned on this false dichotomy between law-abiding community members and criminals, and they see their duty to justice really in a binary fashion to keep the good people safe from the criminals. And I think not only is that a very dangerous oversimplification, but it shifts the accountability from those of us with the power and the privilege in society to define not only what crime is in a very literal sense in legislation and in courts, but also, to the racial profiling point, who is policed for crime? Who is watched? Who is stopped? Who is contacted? Who is harassed? Who is ultimately arrested and charged and prosecuted? There seems to be this misconception on the prosecution side that it's a level playing field and everyone who may have committed a crime is being prosecuted, regardless of their race, regardless of their membership in any other category that we as society put on them. And that's just not true. If you are white, housed, and have some financial means, you can literally be engaging in the exact same conduct as a lot of my clients and never even have any contact with law enforcement, let alone charges and prosecution. So I think, again, there needs to be a broadening of the gaze for prosecutors and in general, what our society views as public safety. Otherwise, we're just going to continue having the same outcomes.
Anyone else want to chime in? Okay, so I wanted to turn to California, and I'd love to hear, Brendan, how you got involved in the legislation in California. Although I know you say there are a lot of other people that did a lot of things, but you were involved as well. So I think you can kind of give some insight for the defenders watching, how they might be part of a paradigm shift in their states beyond just trying to fight those individual battles and bats in the courtrooms. How did you get outside of the courtroom and really push for change like the ones enacted in California?
Sure. I think it was a little bit by chance that we got involved in legislation more actively, especially in my office. One of the things that we set out to do was really balance juries. You know, we have attorneys here who are trying cases in Alameda County, which includes Oakland, and they're trying case after case after case. Our clients are primarily Black and brown, and there are no Black and brown people on juries. So how are we going to fix that? One of the first ways we engaged with legislation was to attack the felony exclusion, meaning that people who have felony convictions are excluded from juries. In California, there's that rule in place that kept over 30% of Black men from serving as jurors because of a felony conviction. In California, you know, the blue state, it was a lifetime ban. If you had one felony conviction, you could not serve as a juror for your entire life, which was mind-boggling. And you could see how that would feed into the system of excluding Black people from juries. And it could be a conviction from 1970 for a possession of marijuana for sale. I mean, stuff like that. You could have gotten it dismissed and off your record, so forth, but it would still keep you from serving as a juror. So that was our first line of attack. It took us 3 years, and finally we found the right Arthur Senator Skinner from Berkeley, who carried the bill, and we got it across the finish line. We passed it. So that was just a huge win. And shortly after that was passed, I received a call from Natasha Minsker, who used to be a public defender in our office, who now worked for the ACLU, and had done some lobbying, and also complete badass Professor Liz Semmel from Berkeley. And if you haven't seen it, she's published a white paper called Whitewashing the Jury Box. I highly recommend everyone read it. It's fabulous. And they reached out and said, Brendan, we're trying to do what they've done in Washington with GR 37 here in California. Do you want to join us? Like, bet, sign me up, let's do this. So that's how we started. And we started right before COVID. We had our press conference in March in Sacramento, like I think it was March 10th or something like that, right before the shutdown. And I actually thought it would take us about 2 years to get it done. COVID happened, shutdown, all bills got pulled, and then George Floyd happened. And then all of a sudden, racial justice was at the forefront of every legislator. And so we seized that momentum, and it was like one of the last bills to get signed at legislative session. We were sitting there watching the TV like a sporting event. It was like 11:56, like, oh, come on, we got to get it done, and it got signed, like, got passed, and yes. And then the governor signed it that year. One thing that was kind of ironic about that, our AB 3070, or the version of GR 37 in California, was passed in 2020. It didn't go in effect until January 2022. It took the bench, argument was that it took them a whole year to be trained on this law. It took them a whole year to learn not how to be racist in jury selection. I thought it was kind of crazy. It took them a year to do that. But it just started for us. We're about 3 months in. And so far, it appears that it has kept prosecutors from using those excuses we've talked about with regards to challenging jurors. And we were fortunate. The list that we were able to get past here included distrust or negative experience with law enforcement, belief that law enforcement engaged in racial profiling, having a close relationship with people who have been stopped, arrested, or convicted of a crime from someone's neighborhood, having a child outside of marriage, receiving state benefits, not being a native speaker, dress and personal attire, and other things. So we were fortunate to get all that included here as those being presumptive reasons why prosecutors could not remove jurors.
Have you seen any, have you noticed from the juries, I don't know how much of this you are in court observing, but have your juries become more diverse? I mean, they're not using these excuses anymore, but do you think it's impacted ultimately the jury itself?
I think it's had a little impact. We're still early because COVID shut down a lot of our trials and we're now getting back up. It has some impact with regards to prosecutors removing jurors. Okay, that's what it's helped with. When it comes to making juries more diverse, there's lots of things that need to be done, lots of ways to attack it, not just Batson, but it has resulted in fairly, I would say, slightly more diverse juries, and definitely has limited the prosecutor's ability to remove people of color from juries.
Did you face opposition, or did this bill get the opposition that Tristan described, which, you know, it sounds like there's just a unanimous no from out of Colorado, but I'm imagining some people, the progressive prosecutor movement, you know, may have made you have, you know, a little bit more of an ally out there, but I was wondering, did you face the same type of opposition?
None whatsoever. I'm joking. I'm being really sarcastic there. Okay.
None.
As a DA, yeah, they opposed it. Yes, I mean, it was every DA association about the state, the California DA Association, LA DA Association, Police Officer Association. It was opposed in multiple ways. And there wasn't really what I'm going to call a satisfactory reason to oppose it. There were reasons given, like they support the current standard that's been used. It said that it was able to eliminate discrimination. It said, oh, well, this is one thing I forgot. They said to change it would invalidate a number of reasons that have long been accepted by state and courts that we should continue to accept. So it's like, so let me get this straight. Y'all are okay with all those racist reasons and you're supporting them. So that was kind of the reasons given here. And I think finally, one of the last reasons they gave is we're getting close to getting it passed. They talked about COVID and little opportunity to engage or discuss legislators, and it would represent nothing short of an upheaval of our jury system in California. And I'm like, upheaval is good. That's what we need. So there was opposition. It didn't gather a lot of support on the opposition side, and so we were able to move it forward. I'm sorry, 2 places where we did not expect opposition to be as strong. The courts were oppositional, and that's where we negotiated that year of training to took down some of the opposition. And there was a mix amongst the court between eliminating peremptories, keeping it the same. Their courts were kind of all over the place on that. And then a surprising place we found opposition was the civil bar. It was just not on our radar that they would be opposed to this. They preferred the law not to be changed, but then we also gave them, I think it was 2 years before it implemented for them, and they were okay with that. So that was an unexpected avenue of opposition.
So do you think that the George Floyd, the timing was just the sweet spot for getting something like this passed? And Tristan, do you feel like the momentum from the George Floyd sort of racial reckoning has kind of waned and we're at a different space now?
We certainly are in Colorado. So I remember when the Colorado General Assembly broke for COVID in 2020, reconvened the day after Memorial Day of 2020. So right at the end of May, right after George Floyd. There were significant protests at the state capitol every single day for the remainder of that session. It went from late May into mid-June. And during those 3 weeks, our Colorado General Assembly passed a pretty groundbreaking Law Enforcement Accountability Act, Senate Bill 217. I worked on some of the criminal law provisions in that bill. I was inside the building with legislators looking at proposed amendments while it was on the floor. And I still believe that the only reason that passed was because of the momentum for racial justice that was being generated in real time by the protesters that you could literally hear chanting, singing, and yelling from the inside of the Senate and House chambers. You could physically hear them through the walls. There was still some of that momentum in 2021, but it stalled out during that session, as we saw with the failure of the bail reform measures. And this year, if anything, I think the pendulum is swinging back the other way because it's an election year, and a lot of the narrative for this election cycle for both parties has to do with crime and public safety. The conservative side is pushing very law and order, huge spike in crime rates with no recognition of root cause where that's coming from, and no entertaining of any solutions besides raising criminal penalties, harsher sentences, more policing, more prosecution, and more money to do that. And unfortunately, we just haven't seen, even amongst many white Democrats who were there for the police accountability bill, we just haven't seen that racial justice momentum sustained on that side. So it's not just in the issue of jury selection. We're seeing it in bail reform. We're seeing it in sentencing reform. We're seeing it right now with fentanyl. A lot of legislators, and significantly not the people of color who are elected to office, but a lot of white legislators from both parties have sort of turned back the clock on racial justice and are focused now more on, well, the public's worried about crime, we've got to address public safety. And what they seem to mean by that is give more money to the police and put people in prison for longer.
So, when we start hearing tough on crime, law and order, that tends to really be bad news for communities of color. It's formed the basis of mass incarceration. Is that something that, Brendan, you're hearing out there in California as well, as that there's a surge in crime, and, defund the police has been a disastrous messaging. People just shy away from it. It's not a lot of, I think politicians are afraid of it. So, is that a trend there? And that's where we're going to see less and less opportunities for reform in the jury space?
I would agree. Yes, it's a trend here in California also, where anything with regards to criminal justice reform or changing in that space is taking a much harder lift right now than Sacramento. It takes a lot more effort, and bills that seem like they had momentum prior to this year aren't being introduced right now. So yeah, the pendulum has shifted. It's swung the other way. It's all about public safety. It's ironic that a rash of retail thefts, literally retail thefts, people stealing from, I don't know, I can't think of the fancy stores right now, Louis Vuitton, all of a sudden it's like, oh my God, we are unsafe. And that's what's happening here. Or someone riding in their bike in Walgreens and stealing toothpaste and whatever, has been played over and over and over and over again in the media. And all of a sudden we are all unsafe. We got to put more and more money into policing. No, that doesn't work. We have to put more and more money into communities so people don't steal from Walgreens. And that message is being lost right now. So yeah, it is hard to hear. I think we still will be able to get some bills passed, but they're very targeted, very, very targeted.
So I think maybe Brendan, it was you that said this, or Tristan, but I love to get into Paula's sort of specialty here. Batson is the tail end of jury systems and how we get to diverse juries. So while we have our captive audience, I'd love for Paula to talk just a little bit about the system itself. And Batson is one piece of it, but there's a huge funnel before we get people into the actual court. So there's a ton of different things that happen before that might be opportunities for reform, or at least educating the community about different ways to diversify juries. And it's not just at the end when prosecutors kick people off, but it's way before that, right, Paula?
Absolutely. Yeah, I've often said sort of the damage that Batson and discriminatory use of peremptory challenges does at jury selection is really it's almost insignificant compared to the damage that happens upstream of actually bringing a diverse jury pool. And I sympathize with Tristan of like, yeah, the push has passed and we're going into a bad space. I'm actually still seeing a lot of forward momentum on some of the upstream problems being discussed with different task forces around the country. Some of which are just looking at our source lists. What kind of source lists are we actually using? Are we starting out with the best possible lists, the most accurate lists, accurate records and addresses, so that when courts actually summon jurors, that they actually get the jury summons, delivered to them, which is not a foregone conclusion, and based on the accuracy of some of these lists. Looking at probably the biggest impact that we see is more socioeconomic, that contributes to people who cannot serve literally because they cannot afford to take the time off for jury service. And there is just not, there are not the protections in there in terms of protections against employment harassment or retaliation for people who are serving on juries. Colorado is actually one of the ones that's actually at the forefront, one of the 8 states that actually requires employers to pay their employees their regular wages or their regular salaries if they get summoned for jury service. And so that's actually quite unusual. There's only 7 other states that do that. But that is a major barrier for a lot of people. Certainly their willingness to serve, their ability to serve once they actually get into the courtroom for jury selection. And if it's anything more than a 1 or 2 day trial, are often being asked to, please excuse me, because if I do this, I can't afford rent and I can't afford to feed my kids. And those are very, very real and legitimate concerns for jurors. And then the other piece of it is just working with courts on what I call a good jury system management, of really working on the integrity to make sure when people don't respond to a jury summons or when they fail to appear for jury summons, that the court is taking reasonable steps to get in touch with them, to reschedule them if they need to determine whether or not they are in fact statutorily qualified and eligible to serve in that jurisdiction. And to facilitate their ability to serve, whether it's, okay, we get it, this is inconvenient time for you, but what if we deferred you out to a different term of service when it would be more convenient? I think those are probably some of the big sort of systemic problems, barriers. The other one is just in qualifications, the felon exclusion. We're seeing a lot of states that are starting to take a very, very hard look at those laws and either eliminate them or at least mitigate their impact, maybe over some period of time, or once a person has actually completed their criminal sentence, that they would regain their eligibility, not only to serve as jurors, but also to vote and to be a part of the functioning civic body again.
Thanks, Paula. So I see we have like 4 minutes left. So I wanted to open it up for any final thoughts.
Well, I will field that, Monica. The thing that I most wanted to share, particularly with defense lawyers on this webinar, was something that I found quite disturbing in the opposition arguments to the bill in Colorado. And I mentioned a little bit earlier, touched on the fact that prosecutors were arguing the bill would have been unfair to them and unfair to the state, and by extension to justice for victims, because of the list of presumptively invalid reasons. And they wanted the opposite presumptively invalid reasons for a peremptory challenge on the other side. And the reason that was so disturbing to me is because although they had already come in and testified that implicit racial bias is a problem in jury selection that needs to be addressed, that position and those opposition arguments completely ignored the reality that for centuries we have had predominantly white juries in this country, and in the state of Colorado, we continue systematically excluding people of color from jury service. And I think until the system reckons with that reality, we're kind of stuck in a holding pattern where we are. So I am hopeful that either by rule or by future legislation, we'll be able to push forward and get some recognition that it is not white people who need to be more included in jury service, it is people of color.
Thanks, Tristan. And I think Monica's joining to kind of close us out. So thank you all on the panel for joining us. And I'm going to kick it over to Monica to close us out with final information.
Awesome. Thank you so much, Monica. And thank you to this panel, Paula, Tristan, and Brendan. So I do want to highlight, because there were definitely a lot of great resources that were mentioned and then sort of dropped in the chat as well. So there is an aggregate page of where we are, putting together all of the webinar resources. And so we will send that. We sent it as a follow-up in yesterday's email. So you'll find like all of the resources aggregated there that were discussed. If there was anything that was new that was discussed today, we'll add it to that. So it'll be sort of like a living document. So feel free to look at that page and get all of the links to the articles, the reports, the legislation, the opinions that Tristan mentioned on that webinar resources page. And I want to sort of shout out my colleague, Monica Milton, because we also have a page, strengtheningthesix.org, which includes a lot of the work that her and the team at our Public Defense Department are doing around, I'm sure, jury diversity that she kind of referenced at the beginning, that Paula and Brendan have been speaking on in previous webinars. And so if you want even more information and hear other content on this topic, definitely visit that resource page, and listen to some of the recordings and the resources that they've compiled that go even further. So if you're looking or interested in that as well. We have shared our panelists' contact information. Again, sort of going to shout out Monica Milton if you do have questions on this issue more in-depthly, the topic of this that are included under the Strengthening the Six page. Definitely reach out to her as a resource on that as well. I want to put up our sort of survey slide real quick. So obviously we're going to, at the end of this webinar, you'll get a sort of link to complete a survey and just let us know about the topic and how we're doing, and if there's any other topics related to this issue that you would like to see NACDL sort of pursue. So with that, I want to say just thank you everyone for attending. Thank you for our panelists. And do want to sort of highlight an upcoming event as well that's happening this Thursday. It's going to be related to sort of second chances. And so for those who may not be aware, sort of April is sort of recognized as Second Chance Month, where a lot of groups, both state, national, local, who do a lot of content or that are seeking to sort of raise awareness on the issues that those who are formerly incarcerated face, but also those who are still incarcerated. So on Thursday, we're going to be sort of talking and featuring a project of NACDL called our Return to Freedom Project. This is where we sort of match pro bono attorneys with those who are looking for relief, whether it be compassionate release, COVID-19, anything that will sort of get those who are often serving very excessive sentences, who are currently incarcerated, avenues for reform. We have projects related to excessive sentencing, the trial penalty, again, COVID-19, and a number of things, the First Step Act and retroactivity. So definitely join us on Thursday if you're interested. We'll hear from some of our pro bono attorneys, but also some of the people who have been granted clemency as relates to the project. Again, thank you so much. And we will, to answer someone's question in the chat, it will be recorded, and we'll send a message out to everyone who registered for today's webinar when the recording becomes available, and it'll be posted for free on NACDL's website. So thank you again. Until next time, for those who can join us on Thursday, I will see you on Thursday.